The topic of this debate is whether state legislatures should pass police reform measures removing qualified immunity for police officers and mandating citizen review boards in each community. Our presentation will argue against such measures. Qualified immunity is a defense that government officials can use or assert as an immunity from being personally sued for violations of civil rights. While this defense can be used by a variety of government officials on the federal, state, and local levels, today we are focusing on how the doctrine of qualified immunity applies to law enforcement officers and why it is an important and necessary protection. The need for this protection was first justified by the Supreme Court in 1962 in the case of Pearson versus Ray. In the opinion in that case, Chief Justice Warren stated that a policeman's lot is not so unhappy that he must choose between being charged for dereliction of duty if he does not arrest when he has probable cause, or being mulcted in damages if he does. The current test for qualified immunity was established by the Supreme Court in 1982 in the case of Harlow versus Fitzgerald. The court determined in that case that government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. As we all know, there have been far too many police killings in recent years. Even one unjustified killing by police is too much. That being said, there has been a backlash against law enforcement officers and the profession in general that tends to paint all officers as corrupt, racist, or evil. This backlash has led to calls for removing qualified immunity protections and mandating that cities establish citizen review boards. While we recognize that the intentions behind these efforts are good, we must be aware of the consequences of such steps. Law enforcement, by its nature, often puts officers in very dangerous, fast moving, and unpredictable situations, in which they have to react quickly to protect themselves and others. There is often no time to thoroughly assess every detail or the potential legal implications of a situation before making a decision. Hesitation in those circumstances could lead to serious injury or death to the officer or to those around him. Without the protection of qualified immunity, police officers could find themselves hesitating or being slow to react in those dangerous situations for fear of losing their savings, their family home, or other personal assets in a civil lawsuit. Without qualified immunity, excessive and unwarranted lawsuits could put judges and juries in a difficult position in which they have to second guess these split second decisions without fully understanding the context and intentions of the officers in the moment. The cost of these lawsuits is also extremely high. This point was made by the Supreme Court in Harlow versus Fitzgerald, and they said, it cannot be disputed seriously that claims frequently run against the innocent as well as the guilty, at a cost not only to the defendant officials, but to society as a whole. These social costs include the expenses of litigation, the diversion of official energy from pressing public issues, and the deterrence of able citizens from acceptance of public office. We agree that police officers need to be held accountable for their actions. Many assume that qualified immunity grants absolute immunity for police officers, completely shielding them from any liability or accountability. This is not the case. First of all, qualified immunity only applies to civil cases. Police officers can still be charged criminally for their actions, and we have seen this in several of the recent incidents of police shootings. Qualified immunity also does not apply if an officer's actions violate clearly established constitutional rights or if the officer knowingly violates the law or acts with clear incompetence. In these cases, officers can be sued and held personally accountable for the damages caused by their actions. Finally, as we mentioned earlier, qualified immunity only applies to suits against officers personally. It does not apply to suits against government entities. Police departments, cities, counties, states, and so on can be sued for damages for the actions of a police officer or other official. Another effort getting a lot of attention over recent years is the call for citizen review boards. Citizen review boards are most commonly established at the municipal level and are made up of citizen representatives tasked with reviewing and sometimes investigating complaints against police officers. The power and authority of these boards often vary city to city, but according to the National Institute of Justice, most are simply advisory groups that review already completed investigations done by the internal affairs departments of police departments. Citizen review boards present several challenges that very often render them ineffective. First of all, citizen review boards are made up of citizens who can bring personal bias and a lack of experience in or an understanding of police work. Citizen review boards can also be expensive to operate. Staff, investigatory resources, administration costs, and so on can cost cities hundreds of thousands of dollars a year or more. All this being said, we acknowledge that when done right, citizen review boards can contribute in a very positive way and provide a more thorough investigation of questionable police conduct. They offer an additional resource and avenue for the public to have their concerns heard and addressed. However, the question today is not whether citizen review boards are effective or not, but whether municipalities should be mandated to establish and fund them. Unfunded mandates such as these can stretch a city's budget and may require cutting other important programs and services. Although we could have an entire separate presentation on the effectiveness or lack of citizen review boards, the point we are making today is that such policies should be left to the local elected officials. Mandating such review boards would overstep the already established jurisdiction of a municipality to provide and manage police and public safety in their communities. If the elected officials of a local municipality want to establish a citizen review board, so be it. But an unfunded mandate from the state legislature in this case, or the federal government, weakens our system of federalism and opens the door to more usurpation of power. In conclusion, let me summarize our main points. Removing qualified immunity would not only cost cities an enormous amount of taxpayer money in litigation fees, but it would also divert time and energy away from pressing public issues. Removing qualified immunity could also make officers hesitate in dangerous and life threatening situations for fear of being sued and potentially losing their home, life savings, and personal assets. Having to face constant civil lawsuits could also damage morale and disincentivize new recruits. This is a big problem because many cities are already struggling with shortages of police officers. This shortage of officers puts the entire community at risk in the form of longer response times, slower investigations, and overworked officers. While citizen review boards are another potential option to increase police officer accountability, they are often underfunded and ineffective. Mandating municipalities to establish such review boards is inappropriate and should be left to the local elected officials. Rather than removing qualified immunity and mandating citizen review boards, we believe there are more effective ways to reduce police brutality and protect citizens. Increase training for officers and better pay to attract more skilled recruits. A universal shared database to better understand where improvements are needed. Increased community involvement for officers and police departments. Increased funding to fight poverty and drug use. Funding for education resources and community centers. These are all efforts that we believe are far more effective. By focusing on these efforts, we can rebuild trust in our police and improve the law enforcement profession for the benefit of all. Thank you.